prescription. It's more cowbell.
I am broken system, broken trust, and I approve this message.
For legal reasons, that's a joke.
I need that money. I really, really do. I need that money. I really need that money. Really need that money. I need that money. I really, really do. I need that money. I really need that money. Really need that money. Really, that money. That money.
Mask on. Fuck it, mask on. Mask on. Fuck it, mask on.
Oh shit. Here we go again.
Okay, guys, let's take I guess I'm gonna pitch my third channel real quick. So reading the room, I just released a video the other day. I have a short coming out today, I had a short coming out yesterday, but that's not the reason we're here. That's not the reason we're here. That's not the reason why all this is on screen. So I am off screen currently because I am going to show you guys the what is it? The people saying that, oh, KFARR's bald. That's why he wears a hat. I have something to show you guys. This is my hair. I have too much hair than I know what to do with, but apparently I'm bald. So let me put this away so I look normal. If you guys didn't know, it is 10 o'clock in the morning. I don't stream at 10 o'clock in the morning, but I have a plan. I have a plan to send you guys somewhere else entirely. I have a plan to send you guys somewhere else entirely. So I'm streaming early. But streaming early comes with me having to hustle through all of my morning chores. Dogs, chickens, kids, feeding kids, getting kids to school. Yada, yada. I got done at 9:57. And I was only 1 minute late. I'll take that as a win. Whew. Man, yeah. And it's funny. I look like this. You would never assume that I have hair down to my chin, but apparently I'm still bald according to people. Oh, but that's what I was working with. I was trying to tame that in the last minute that I had left, and I'm just like, I don't have the time. We're here to watch this video. I've seen a couple people cover it so far. I saw Law Talk with Mike cover it first, then I saw Old Squishy Gardner cover it in a video, then I saw Colin stream it last night. I watched, I think somebody, I'm drawing a blank on who it was, they just posted it, that they watched like half of it. D-Man, yeah. I watched 15 minutes of it on my walk to get the kids from school yesterday and just never picked it back up. I just was busy yesterday, didn't have time. I got the gist of it. This is a terrible human being. I was going to say, oh, he should be arrested and castrated. And then I found out more information that made me double down on, yeah, he should definitely not be in public, yada, yada. I heard 3 letters as I was walking in my door before I turned it off, and it was CSC. And CSC may mean something different to everyone else, but to me, it means criminal sexual conduct because we saw that charge regularly in the jail. So right there, I'm just like, wait a minute, maybe this sovereign citizen is somehow more scummy than usual. And I was right. We're gonna watch this. Let me orient myself correctly on the screen before we get into this. I pulled Old Squishy Gardeners. That's what we're gonna watch. I was gonna watch Mike's video that he covered, but it was just, it's weird using Mike's videos because sometimes he talks and like sometimes he doesn't. So I didn't want to risk a random thing he said doing anything on my channel. So yeah, let's roll this beautiful, beautiful bean footage of a crazy sovereign citizen. And so this judge, I've seen this judge, Wiggins, before. He makes a great point that the sovereign citizen really doesn't have any response for. And that's when I'm like, I'm gonna show this video. So here we go.
Nonsense that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus. False in one thing, false in all. I'm not contracting with this. My constitutional rights are broken.
All right, court next calls the people of the state of Michigan versus Philip Andrew Leffers.
And yes, our First Amendment right.
This is, all right, this is case number 26819FY.
And the moment a defendant won't step into the well, if you will, won't cross the bar, contempt. I'm tired of them causing such issues. Sure, let's watch it at a fancy setting. Yeah, I'm tired of them causing issues when contempt could have solved that issue, if you catch my drift.
Why? We are here for a probable cause conference. We're also here, Mr. Champion has filed documents on behalf of Mr. Leffers. One of those is an affidavit of non-acceptance of court-appointed counsel, assertion of constitutional rights, and demand for self-representation. The other is an affidavit of notice and acknowledgement and acceptance of oath of public official. The other is a respondent's motion to set aside a default judgment. Before we begin today, I'm going to remind everybody of the court rules and local administrative orders regarding the court decorum and procedure. I'm going to ask if anybody is recording these proceedings that these please shut off their phones. I'm also going to ask that any phone be placed in a pocket or purse in such a way as it cannot be seen from the courtroom. If you could stick that in your side pocket, sir, I'd appreciate it. Appearances, counsel.
Lisa Doe for the people.
Robert Hertel for the Defender's Office. Your Honor, Mr. Champion was in Misaki this morning. I'm sure the court also took note that what we, from the Defender's Office filed, we included a qualifier of it not necessarily being endorsed by the Public Defender's Office. I wanted to make sure to stress that.
Correct, I understand that. So, Mr. Leffers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hertel. Well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other, so go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable.
Anytime a sovereign citizen says, with all due respect, or anything similar to that, nothing respectful just came out of their mouth or is about to come out of their mouth. It's like getting a compliment from someone and then they say, but, I mean, everything before the but means nothing.
I am Phil Levers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. I voluntarily appear in this court today on special appearance. I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments in the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added. And Mr. Champion also And RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter.
Anytime a sovereign citizen comes into court and says, well, anytime the state has a problem with a person, it automatically goes to the Supreme Court. By that logic, anytime you break the law in the state, it should go to the Supreme Court. Like, make that make sense. And to my knowledge, that's not what the Supreme Court is about at all.
Invoking my Sixth Amendment right, as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins, and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance.
I'm just going to, this is going to be a clip, and I genuinely don't care because you read the title. If you don't agree with me, you support sex offenders. So I don't believe that this guy should be out in the public. So if the officers want to swear at him when he does something wrong, I don't care. The fact that he's doing the Chris Ryder. He's trying to pretend he's the victim, while it seems like he's the defendant in the case, which means he's inherently not the victim. You can't be the victim and the defendant. Like that doesn't mesh for a criminal case.
Want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration, or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court.
Okay, all right.
On a federal indictment, which as a national, we're in different jurisdictions, sir.
So I understand you want to represent yourself. I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown, the past 2 judges have been removed by the tenure council. So Canon 1 through 5.
Who was I on? I think I was on with grammar school, and we talked about, oh my Lord, it wasn't Mark Stevens. Drawing a blank on who it was, but he's like, oh, I actually got this judge and this judge disbarred, and they can never hold office again. But then if you took any time to look into it, like that never happened. There's your sign. It kills me. It pains me that sovereign citizens get into court and then actively lie out of their ass, and people are just like, okay, like, no, cool. You can do contempt for that, my guy. I'll see you in 30 days. Hopefully you smarten up.
D, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even unpro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay, so I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory.
You have a permanent mental disability. We get it. I believe it. That's the first time a sovereign citizen spoke, and I went, yep, I bet that's true.
It's gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all three parts here. So
I watched your videos while you were a judge. I watched the one of the two gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same two officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did. And I watched two other videos, which they fully got what they deserved. They broke the law unequivocally. But those two gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here.
Hey, I don't think he's going to say anything about the flag. Is it gold fringed? I don't know if it's got a gold fringe. If not, I don't know what he's going to say. It looks like if I was a judge, I would just keep random fancy flags with the gold fringe lying around just to put in court when I knew a sovereign citizen was coming. Yeah, the rumor has it the living man is in a grave somewhere. This is the dead man. The dead man's in court testifying. Ed, how you doing?
My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's now $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these two officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property. The officer also stated that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus. False in one thing, false in all. And if you begin it by a lie, how can you be credited to be believed at all? So the officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak. So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So where I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, proper, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on the public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let me ask you, and I understand why we're getting a little heated, but
sorry.
Hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank.
Okay, so this is around where I got to and stopped watching. So this guy is going to ask for just the absolute craziest shit in discovery. Shit that has nothing to do with his case at all. And the judge even just goes, what? But because he's a sovereign citizen, he thinks he's entitled to, I don't know, the JFK files because it's discovery. What? Why don't you just ask for the whole video? That's all you're really entitled to in discovery if that's all that has, like all they have for your case. Body cam, dash cam, maybe the report. That's it. But some of the shit he's asking for is just fucking wonky.
Again, I'm on a time clock here.
Correct.
So let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the police report?
Defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point. And it crashes every single time.
But they at least
RJ stated, he's like, I just watched all of these. I don't understand what's going on.
But they at least attempted to play it for you and then it crashed.
I wasn't.
Presumably.
Discovery means that the evidence goes to me.
No, I understand, but just focus on my question for a minute. My question is, were you given the opportunity to at least try to watch the video? I understand there were some technical issues, but did you at least, you were given that opportunity?
Yes.
And were you given the opportunity to review a police report? Maybe not handed, but did you at least, and don't talk about what they told you because I don't want to get into attorney-client privilege, but did you at least have the opportunity to generally say, okay, this is what the police report says, what do you say, and then kind of merge the two?
The insinuation of attorney-client privilege against her, please.
Well, I have to be careful with that because I had appointed counsel.
Correct.
So I'm setting that aside right now. So at least by the time that you had counsel appointed, that's what I'm considering attorney-client privilege.
All right.
Not from here forward, just during that time period that you were with either Mr. Jockins or you were with Mr. Champion.
Yes.
Yeah, shit. Yes, Giggles. Maybe he can ask for Chris Ryder's files in Meade County. Rumor has it Chris is looking for an attorney. Maybe this guy can help him out. It's just some people. Where is it? Right here. Yeah, he should have been disqualified for admittedly having a traumatic brain injury and not being able to remember anything. Should have automatically disqualified him.
Did you at least have the opportunity to go through a police report? Maybe not being handed to it or handed it.
We're given the addition to the police report. We were given the police report originally by Mr. Jockins.
Okay.
Which at the bottom of the police report, and there's no signature of any witness.
All right, Mr. Leffers, I need you to focus on me because this is one of the rules of the court.
Yes.
It's not appropriate for you to be interacting with a member of the audience. And I realize that you're married and you're one, but
Memory.
yeah, I understand. And that's where why I have concerns about the memory aspect and allowing you to just represent yourself on your own. And that's one of the reasons I'd asked that question about whether you'd be open to of counsel situation where they're there for you to talk about the case. Sorry.
As long as it's completely, and if we have to sign an NDA, fine. I would prefer not to. I mean, I have nothing to hide. But if we have to sign a contract stating, I'm not contracting with this, my constitutional rights are broken. I know what lawyers are about. We've read it. Now, that's not saying everyone's that way because there's moral and honorable. But most of them just want that money. And I know where their allegiance lies, just like I didn't know that a judge also has a banker's oath. But yes,
so all right,
I would do my best.
So it sounds though that you want to represent yourself, but
here's the part where the judge just kind of throws up his hands because he's like, the judge, I didn't know the judge has the same oath and has a banker's oath. What? The judge isn't a banker in any way. This isn't a business.
You're okay with having an of counsel position that you can talk with, make sure things are being filed properly and that sort of thing. Not that they're representing you, but just to be able to bounce ideas off, so to speak.
I reserve all rights through equity and trust law and under the Constitution. And as long as that's not violated, I don't have a problem with that.
All right.
That's what I'm saying. Now,
so if I allow you to represent yourself, are you going to be able, again, to comport yourself? Because realize that in the grand scheme of things, right, the Supreme Court's up here. I'm the district court. I'm way down here. There's lots of courts to get through before you get to the Supreme Court for appellate purposes. So a lot of the things that I'm left to decide are necessarily what the law says, what the Constitution says, the Constitution that is currently before me. There isn't, the appellate courts would have to tell me I'm wrong. Do you understand that?
Sure, but we could read the Constitution.
No, I understand that, but what I'm saying,
Article 3, Section 2.
but what I'm saying is because I've also noticed that in some pleadings you said that you're not a 14th Amendment citizen, but hold on, but yet in the last pleading you said I was violating your 14th Amendment.
It's a compilation of both.
Well, but see, it can't be. So,
But it is,
but see, that's where things kind of go off the rails, because you would agree with me, right? That if you are not a citizen of the United States, let's say you go to Japan, for example, all right? Are you not then subject to Japanese law if you're on their land? Whether or not you're a citizen, you would still be subject to Japanese law, correct?
No.
No, it's not an analogy.
Yes, so if you went to Japan and broke Japanese law, according to him, it wouldn't matter. I love that this is the argument the judge is trying to use. Well, if you're not a citizen of the United States, let's take this to a different country. If you are not a citizen and find yourself in Japan, does Japanese law not apply to you? Right there, logic train got derailed from the sovereign citizen. He should have gone, okay, I apologize, Your Honor. I didn't realize how idiotic I was sounding. But no, he's just going to triple down on shit.
You still retain your U.S. rights and citizenship, but the minute you would step into that territory of Japan, you're then subject to their laws.
Anything that abrogates the Constitution and its amendments is unlawful.
But the Constitution doesn't apply in Japan, right?
Well, it does. Because what national are you? That's also protected internationally to the international court.
Mr. Leffers, I will allow you to represent yourself, but I'm just forewarning you that you are going to be held to the same standards and procedures, whether or not you agree with those standards and procedures, because that is what I'm bound by. The standards and procedures that have been set by the Supreme Court, the laws of the state of Michigan. And when I say the Supreme Court, I mean both the Michigan Supreme Court and the United States Supreme Court. The laws of the state of Michigan, and to the interpretations and case law of the when it comes in regards to interpretations of the U.S. Constitution and the Michigan Constitution. Now, I realize that you because you cited the 1850 Michigan Constitution. In this court's eyes, I believe it's the 1963 is the date. Don't hold me to that exact date, but the latest version of the Constitution. When citizens are able to pick and choose which things they agree with in the Constitution and which things they don't agree with the Constitution, that's where things run afoul. And that's where it takes a court a lot higher than me to make that decision. So it's a long-winded way of saying is I am only going to be bound by what is appropriate for this court. If you need to take it to higher courts, that's certainly your prerogative. But moving forward, can you at least agree to that?
Okay, so from what I remember is that the judge or the prosecutor, depending on how they file it, in which the prosecution filed it incorrectly, especially after finding out about my nationality status. Nationality status is protected by the Constitution, and the Supreme Court has ruled on that several times over. Now, the prosecuting office is supposed to refile their paperwork then and go for a grand jury indictment.
So there's a proper procedure in which you have to go through to do that, and this is not that proper procedure.
And if the prosecutor doesn't want to do that, then it falls upon you to make the decision, where the truth is what it is. And Ezekiel 3:18-9. If we are seeing someone in sin and we don't say something, on the day of judgment, whatever you have seen, for anyone you didn't say something to, you will be judged for.
I just want to point out that how dumb this guy sounds. I have an issue lately with people that try to quote the Bible as a defense for their own wrongdoing. Great example. I know somebody, a man of small stature, who has been running around insinuating that multiple people were sex offenders or pedophiles, if you will, but then getting mad that other people are bearing false witness against him. God plays no role in this type of situation. Like, I'm sorry to break it to you. Sir, also, I think God probably took one look at you and went, nah, Muhammad can have you.
So, sir, I respect you and your honorable ways that I've seen the Constitution and my rights being broken and trampled on. My due process is broken. I cannot get an impartial anything in this county.
So what'll happen is if I allow you to represent yourself, you would then be able to file the demands for discovery, and the prosecutor would have to turn over to you what they have for discovery.
Well, it's not just that.
No, but I'm just saying, so that's one, that would alleviate one concern that you have.
Yes.
And then I understand
information to be executed and relieved over to me, which entail all of it, the financials. 12 bonds that have been opened up.
So they can only, so hold on. So they can only provide what they have at their disposal. They can only provide what they have at their disposal. They can't go out, or they're not required to go out and seek information that, let me rephrase that. They don't have to go out and generate discovery. If they don't have it, they don't have it. Does that make sense? So if they don't have a specific bond that you're requesting, they don't necessarily have to go out and get that bond. Do you understand that?
With the paperwork I filed, with the UCC laws on it, it clearly dictates and describes all the evidence that I'm asking for. Now,
and this is where you get to step in as the lawyer. What authority do you have? What case law do you have that says that the UCC applies in a Michigan state criminal charge?
The fact that it's tied to the case.
How?
Because the bonds got opened up through the case number.
But
so where do you get that?
Where do you get that from?
Social Security number. You can look it up on Treasury Direct.
But that's not my responsibility.
No, it's not.
So
in due diligence and learning, we started looking. Multiple friends are helping. So
it sounds like a lot of his friends are pretending to be his attorneys. First off, unlike some people who I've been arguing with on the internet the last couple weeks, I don't carry water for sex offenders. If I was to find out you were a sex offender, I would out you publicly and excommunicate you from my life. But some people that I've been covering don't have that ability. So the fact that he has friends means those friends are either sex offenders or shitty human beings. Second, they started bonds during the trial, blah, blah, blah. Grow up. Anytime a sovereign citizen says, well, once I got charged with these things, we started to learn and we started to educate ourselves. You ordering a packet from some brain dead sovereign citizen guru online does not mean you're educating yourself. It means you're digging yourself further and further into the hole.
Pointing us in the right direction. So we have literally seen it. We have photographed it. Over 12 bonds have been opened up with a numerical value over $500,000. As of right now, over $500,000 in EE bonds and I bonds have been opened up off of this case. The only thing attached to this case is my social security number, which my estate owns.
So who opened the bonds?
Well, I would have to be given time to file the paperwork, which I've already been filing. I've already filed with the Trade Commission on the fraud that I did not authorize these, and I want to see the wet ink signatures. I also filed for the fiduciary change to Treasury Secretary. The ID will be coming back.
Gonna do the Chris Ryder, leave a 1 or 2 in the chat. Leave a 1 in the chat if you like Broken System, Broken Trust, Lions court shirt, or leave a 2 in the chat if you like this guy's overall court pants outfit. I'm digging the overall look, not the Detroit Lions shirt look. So 1 is Detroit Lions shirt, 2 is overalls.
That was wonderful because there's a few documents that I have to scan my ID for before I can submit them to the state to continue moving through for my nationality status in whole.
And who do you apply to for your nationality status in whole? Because you were born
a lot of stuff. A lot of stuff. You got to set the IRS correct. You got to set the Treasury Secretary correct. I got to send a letter to the governor. I got to send a letter to the head sheriffs. And like when we lived in Alabama, it was a sheriff's director board or whatever. They had a meeting every week. I'd have to send a letter of notification of the revocation of the driver's license and driving privately. And already switching over the titles to the trust, just running low on equity, which is why the other reason her case is tied to mine.
All right, let's go back a little bit here. Let's go back. I wasn't paying attention like I wanted to for this part.
To the trust, just running low on equity.
Your trust and equity has nothing to do with your current criminal case. Just wanted to point that out. The fact that you're trying to make, he's trying to put all of this onto his trust. And it's like, dude, the trust isn't the sex offender. The trust wasn't the person who didn't register on the registry. You know what I'm saying? Like, the trust didn't do that. That was you, bro. Like, that was fucking you.
Which is why the other reason her case is tied to mine. Misconduct. They removed her as the victim. She can't use her place properly. And she's doing the best she can. We would both be working. I had to stop working because my foreman found out about my CFC, and he tried to squish me with 6,000 pounds of steel that I just got done welding up.
like I said, so CSC, I heard that and went, criminal sexual conduct. Oh, somebody tried to squish you with several pounds of metal or several tons of metal after finding out that you were committed criminal sexual fucking shit. Okay, yeah. I get it. I understand that logic. Case out of, what is it? Texas. Dad caught a guy doing inappropriate things with a kid, beat him to death, and they're just like, thanks, no charges necessary. Like, okay.
That was the second job. That was DCL, Traverse City. Before that, it was Stage Right out of Clare. They loved me so much, they didn't want me going to third. They offered me first after I got out of the temp service, because I got into the temp service because I have documentation from the stores department stating you don't have to register because you are not a Michigan resident. We support jurisdiction and constitution. But once you sell your house and you're no longer domiciled in Adams County, Illinois, you have to get a Michigan license. So I registered in the private and have registered.
So he registered, it seems like he registered as a sex offender in the private. So nobody knew that he was a sex offender. That seems like your, what's the word? What's the term they used in boot camp? Circumventing the competitive system. It seems like he had to register as a sex offender in a certain state, but he left that state and never picked up a new state because he was basically transient, for lack of a better term. He never picked up a full address, which means he was probably living in his car, hotel hopping, living in a camper. That way he wouldn't have to register anywhere because in his mind, he belonged nowhere. Ed, it's because he's self-snitching as a fucking sex offender. It's the wildest thing.
Registered in the private of my own free will and volition to prove I am not a threat to a community.
He registered in the private voluntarily to show the community he wasn't an offender. But by registering in the private and not in the public, you're making it private, therefore not showing your community. My guy, do you not... We run into this a lot with frauditors, sovereign citizen Moors, and let's just say people I've been arguing with on the internet for the last couple months. They don't have like the most solid of grasps of like, they don't have a solid grasp of the English language. They don't have a solid grasp of this word means this definition. You can't just say this word and then say something that's not the definition and say, yeah, that's what it means. That's not how words work. That's not how the English language works. To my knowledge, that's not how any language works.
That if there ever is a problem, you can call me up because the only ones that can see me are y'all.
What do you mean by that?
When we moved down to Illinois, they sent a letter. They never would have prosecuted me. They never would have charged me. Here's a letter stating that as long as you're an Illinois resident, you will never have to register another day in your life. Wow. I was able to hold the job for 13 years. Didn't get pushed off, didn't get hit, didn't have people trying to kill me. That's why we left Michigan. And it went to our children in public school. They were tormented, tortured, but I have documentation proving all the way from Ottawa County, Ottawa, Granville, Grand Rapids, Mecosta, stating I didn't have to register. And I am doing it of my own free volition to protect those that might think nefarious ideas about it.
So because I noticed one of the pleadings that you filed before, you mentioned that you were I think you said you were a resident of Kent County?
Yes, sir. That's our in-care address.
Okay. All right. Now, so when you said that we're the only ones that are able to see you, are you talking about because of the registry?
Oh, no, that's been changed since I sold my house.
Okay.
The house was locked up for about 2 years because the neighbors were so bad. Liquid Drano bombs over the house, attempted arson of the house. Yeah, and we homeschooled.
So when you said that we're the only one able to see you, I guess I need some more. No, hold on. I need some more clarification. What did you mean by we're the only ones who are able to see you?
Okay, so the SOARS department,
Okay.
when we first came back to Michigan, I contacted them. They said, well, we're going to have to look into this. We don't really know what to do. So they got back with me, stated, you don't have to do anything. Like, what do you mean? Like, you don't have to register. You don't have to notify anybody anywhere you go in the state of Michigan. You're not a Michigan resident.
Okay.
I'm like, okay, but I was charged in Michigan way back then, and I don't want anyone thinking anything wrong. The SARS department flat out stated, look, if you want to register, you can. We will keep you in the private registry section. We're the only ones that will.
We'll keep you in the private registry section. That defeats the whole purpose of being a registered sex offender. Like, am I just reading this wrong? Or is that what he's saying? He wants to be registered privately as a sex offender, which defeats the whole purpose of being a registered sex offender. You created a victim. It seems like you got convicted of creating said victim, and now you don't want to take responsibility for creating the victim. Like, I'm kind of like, I've seen Dumb. You guys have watched me cover Dumb. I've covered Todd Bryant and Chris Ryder this month, so you guys know what Dumb looks like. This guy. And it's probably, he's a private sex offender. Yeah. So in my head, he either got convicted or took a plea deal for this. And one of the stipulations was to register as a sex offender. And he's just trying to say, well. No, I don't want to make any fucking changes to my computer. Stop it, fucking Windows. He's basically saying, yes, I did this thing, but you didn't say I had to register publicly as a sex offender. And it's just like, you're trying to circumvent the competitive system. Dude, you touched someone to qualify you for the registry. Get on the registry.
You are law enforcement. It's like,
okay, so I know what you mean. Okay, all right.
So SOARS department and I, when I went to Ottawa County, Fillmore County Complex, wait, what's going on? You're not a sex offender. I'm like, no, I'm not.
So they were going to register.
They didn't know what to do. They had to get on the phone with the SOARS department. I was in that waiting room over an hour and a half, allowing them time to get everything situated. And then I willfully went on the sex offender registry that I didn't have to do because the SOARS Department of Michigan respects jurisdiction and constitution.
All right. All right, Mr. Leffers, I am going to allow you to represent yourself. Again, we've got an understanding that you're going to do the best that you can to be compliant with the court rules. Also, I'll allow the Public Defender's Office to remain on as of counsel so that you can reach out to them. Not saying that they're going to represent you, but they're going to be there for a resource for you. Okay? And so that means from here on out, you're going to be able to represent yourself and you're going to be held to the same standards as we discussed. And I can give you some leniency, but not a ton.
I got to let you know, though, this can't proceed. I cannot be a part of fraud.
But so Mr. Leffers, this is where we get into the procedural aspect of it. This is where you will be able to file motions. You'll be able to conduct the hearing. And then that's where you'll be asking me to make a determination as to whether or not the case goes forward. But understand there's only certain ways that can be done in a criminal matter. So just because you stand here today and asking for that, what I have is your word, but the prosecution doesn't have the ability to put anybody on to contradict your word. And so we would have to have an evidentiary hearing, which is essentially what the preliminary examination would be for. And that's the next step in the proceed. Well, actually, the next step would be for you to meet with the prosecutors, see if there's a way to resolve the case, which I understand if you don't want to. And then the next step after that would be what we call the preliminary examination. And that's where witnesses would take the stand. They would testify. You would have the ability to cross-examine those witnesses. You would have the ability to call your own witnesses. The prosecution can examine your witnesses or cross-examine your witnesses. And then you can make your argument then as to whether or not it's whatever the arguments you want to make as to whether or not the case should be dismissed. Today's not that proper time. That proper time is you're gonna get it, but it's gonna be at some different point in the future. Do you understand that?
Yes, sir.
All right.
May I say one last thing?
Yes.
Victoria incumbent Unis from Bondi. The burden of proof is on the plaintiff that originally brought the charges.
That's correct. And when I say that you get to make an argument, you don't have to present any evidence. They can get up there and put on their witness, and you can argue as to why I should or should not move the case forward.
Okay. I need to be allowed full access to everything. Not, well, set up an appointment. I get up at 2 a.m. I go to bed at like 12:30 at night. So I have a lot of time on my hands.
So what'll happen is
you'll and having to set up.
All right. So the fact that this guy's admittedly getting what, 2 hours of sleep a night? Nah, bro, you're crazy. As someone who doesn't sleep, it's not good for you, especially only 2 hours a night. Like, yeah, that's probably why your brain is in the gutter. Not sleeping is like throwing your brain into a blender, just hitting pulse constantly. That's why you can't remember shit, because you don't sleep. So saying, well, that means therefore I have all the time in the world. Then why hasn't this gotten done already? If your public defender said, hey, we would like discovery, they kind of like have to give it to you. This guy is he's making it very easy to think of him as an untrustworthy human being.
So there won't necessarily be an appointment with the prosecutor's office. What will happen? Now it's been a while. Hold on. It's been a while since I've been there, and this is part of the procedural aspect of this. You will have to file a demand for discovery. All right. You'll have to file that with the prosecutor. Now that you are going to be representing yourself, you would file a demand for discovery with the prosecutor's office. Outline everything that you want them to produce, understanding that they only have to produce what they have in their records. They don't have to go out and find things to help substantiate your case, right?
Correct.
Now, they do have a certain amount of time in which to do that with. So it's not like you can file today and request it tomorrow. They've got a reasonable amount of time, which the Michigan Supreme Court has decided is 21 days to comply with that request.
Okay, that was a quandary that we came across. We've seen 5 days, 7 days, 21 days. We couldn't exactly pinpoint anything for sure. So thank you for clarifying.
So yes, the Michigan Rules of Criminal Procedure adopted by the Michigan Supreme Court says that they have 21 days to comply. If they don't comply within that 21-day period, then there's other avenues that you have to either force compliance, or if it's such a out disregard for the rule, it could result in a dismissal of the case. That's a very extreme based on just discovery, but that is a potential outcome there.
Okay, and all the times before this don't matter?
So all the times before, you were represented by counsel, so those requests would have had to have come through counsel, which is how Mr. Champion got it and how Mr. Jawkins got it.
But that goes against what I was stating, and I objected to it.
I understand that, but again, that goes into the procedures that the Michigan Supreme Court have set up for the courts to follow. But now that you're representing yourself, you are in a completely different place than you were before.
May I be candid?
Sure.
So does that mean that what?
Can I be candid? Sir, that me saying yes or no hasn't stopped you to this point. We're 38 minutes in, and you've been as candid as one can be. And my guy, you admitted to what is it? You self-snitched on registering as a sex offender in the private. Yeah, you were pretty candid on YouTube, no less. This is Zoom court on YouTube. You just let the entire world know you were trying to circumvent the sex offender system.
All of the court dates up until now was the inquiry competency test.
No, nobody has requested competency on you. Well, Mr. Jawkins did. Mr. Jawkins did. We didn't even get to that point. Yep. No. What we've been doing is I want to make sure because as I said, I'm the independent party here. I want to make sure that your rights are protected, that you're getting the adequate representation and the right information that you need in order to make sure that your rights are protected. Now, I understand that you might not agree with some of those procedures and it might not be moving as fast as you wanted it to, but that is why I don't remember whether I had appointed or requested Mr. Jockins an appointment for him, but I know I specifically, when we removed him from the case, I do specifically remember requesting another appointment of an attorney. Because again, once you step into the role of representing yourself, that puts you at a whole different level as far as compliance with court rules, procedures, appellate rights, as opposed to having representation. So I wanted to make sure that you had every available opportunity to you. Now, all these dates that you've had, they all go to what we call the speedy trial clock. So because you are charged with a felony, you have to be, because you're not in custody, it's a little bit different. But we all look at the speedy trial clock as being 180 days before you should be at trial. All right, because you're not in custody, there's some grace given to that. But all of these then look at whether or not who these delays should be accounted against. So all these dates you've had were not in vain. They're one to make sure that you're getting the appropriate representation, and they will be considered when it comes time to a speedy trial clock decision if you get to that point. You may prevail at preliminary examination. We don't have to worry about speedy trial.
In reading, if I agree, then that means I'm ignoring all of the past times. That the things I've stated about the Constitution, Article 3, Section 2, Clause 2, are being ignored, and I'm okay with that. I'm not okay with that.
You're not saying that you're okay with that. What you're doing is you're going to get your opportunity to raise those issues. It's just not right now. It's going to be at a point a couple dates down the road.
I object to all of it.
All right, I'll note your objection.
But if I have to go through this, fine.
Okay. So I'll note your objection. I'll allow you to represent yourself. The public defender's office will remain on in of counsel capacity. We will reset this then for a probable cause conference. Now the other issue, hold on. The other issue is you had also filed a motion to set aside a default.
Yes, sir.
There has been no default judgments entered. So
that came in the mail. We didn't know what the heck was going on, no offense.
So let's go back. Let's go back. This is why some people just simply shouldn't be able to represent themselves.
Now it's going to be at a point a couple dates down the road.
I object to all of it.
All of it. He's
right,
out.
I'll note your objection.
He's out on all of it.
If I have to go through this, fine.
Okay. So I'll note your objection. I'll allow you to represent yourself. The public defender's office will remain on in of counsel capacity. We will reset this then for a probable cause conference. Now the other issue, hold on. The other issue is you had also filed a motion to set aside a default.
Yes, sir.
There has been no default judgments entered. So
that came in the mail. We didn't know what the heck was going on.
So he came into this on his own without his attorney and filed a motion to set aside default judgment where there was no default judgment. What are you doing? Tell the judge you don't know what you're doing without telling the judge you don't know what you're doing. That's it right there.
No offense.
What came in? Was there a civil infraction with this?
Yes. It was slipped in when I left. I didn't fully grasp.
There is a civil infraction?
It's a fail to pay booking fee.
All right. So
Sir,
I will grant that request.
I got an object to it though.
Yep. Go ahead and object.
Sorry. My wife and I went in on a Saturday before I went and worked with Bob, Travis's cousin. And the gentleman on the phone said that the booking fee was $12 and you could pay it at the kiosk 24/7. So we went in and we paid the $12 and it apparently still stated that monies was owed, fiat was owed
to the kiosk, which didn't make any sense unless all the dumping of whatever charges were added on. But we have.
At no point should this man have been able to. He shouldn't be able to represent himself. This guy clearly doesn't know what the fuck he's doing. The judge, yeah, like I understand the judge is trying to give this guy some leeway because he seems, you know,
tyrants beware, mentally disabled.
But at what point do you just go, bro, we got to shut this shit down. I got other shit to do. You guys hear me preach all the fucking time. Let me make myself large. Maybe I'll clip this out. If somebody wants to clip this for me, feel free to clip it. I understand he's trying to give him leeway. I understand that. But at what point do you just shut him down and say, bro, like, this isn't it for you. Like, this ain't it. This isn't your thing. I think he said he was welded or some shit. Stick to that shit, because this ain't it. You being an attorney, you represent yourself, that shit ain't it. You're not very good at it. Like, the judge is saving him from himself if he just shut him down. Yeah, the competency hearing is looking real fucking nice about now.
Receipt for the $12 of the booking fee that we were informed personally on the phone from a Wexford County officer. And the website also says that it's a $12 booking fee. Then we got that, I got that in the mail. This is preposterous. This is nonsense.
All right. So what I'm going to do is we will, I will set aside that default. And
Thank you, sir.
We can deal with that in a normal course of business in regards to that.
Thank you, sir.
All right. So Mr. Leffers, you can go out to the front window where you checked in. Is there somebody out there to give him a court date?
Yeah.
And get your next court date. Okay.
Yes, can we speak about that, please?
Yes. Very briefly, because I'm
When-
now
when
an
are
hour
you
behind.
thinking?
So my thought is PCC would be reset for next Tuesday. Will that work for you or no?
Honestly, no.
Okay. So will the following Tuesday, which would be the 19th, will that work?
19th would be fine.
Okay. So we will reset it for the 19th. That will give you time to get discovery requests to the prosecutor. And it'll be set for 10:30 on the 19th.
Now, this means that I will be able to have all the discovery within my.
So remember, they've got 21 days to comply, but my guess is since they provided it to two different attorneys, they can probably get it to you within a 2-week time period.
Well, no, I'm not talking about the time frame, sir. What I mean is the actual tangible, me being able to download all these videos on my phones. It's not going public.
So
it's not going public.
So
they don't necessarily care if it goes public or not. They're more than likely going to give you a flash drive and say, here you go. Or I know a lot of people I assume back in the day, states bought a bunch of CDs thinking this is going to be this is the best technology can get. So they're still handing out like fucking CDs to people, even though like I have a PC, it doesn't have a fucking CD reader. Shit, my Xbox doesn't even have a disc reader anymore. Neither of my last two laptops had disc readers, but they might give this man a disc and say, this is what we got. But it's going to be a disc or a hard or a thumb drive. And they're going to say, here you go. And then it's yours. You shouldn't put it out to the public because that would taint the jury. But as soon as they find out that you registered as a sex offender privately, they're probably going to, it's probably going to taint them as much as it needs to. But like, yeah, you're not going to, he hurts my head. I'm sorry.
What'll happen, I don't know how it works anymore in their office, but they'll either provide you a link to click on, or you'll get a CD to put into a computer. However they do it, that's how you'll receive it. I think they do it by link now, where you'll be able to click a link and download it, but don't hold me to that.
Now,
but you can talk with the prosecutor's office about the best way to get it to you.
Now, there's a discernment with that one. If it's a link to a video, how am I supposed to make sure that that thing hasn't been doctored up or anything?
Well, that's where you as your attorney get to figure that out.
Unfortunately, I don't have the accessibility of resources at my hands as a prosecutor does. So,
bitch, do you not have a phone? Do you not have a fucking laptop? If they give you a link, you click on the fucking link. It's that easy. You click on the link and go, Yep. If the timestamp jumps several seconds or 2 seconds and there's no video playing, they may have cut something out. Again, I'm not a computer scientist, even though Chris Ryder thinks I was some sort of an IT guy, which is weird because my name is under booking officer on like hundreds of people's booking sheets. But yeah, I'm not a computer scientist, but even I can figure that fucking shit out. Of course, it's been doctored up. It doesn't fit my narrative. Therefore, it's AI. Therefore, you guys made it up. You did it out of context. Again, this guy, there's no way that this guy should be able to represent himself.
If I were to want to have a video authenticated.
So there's a process. So the court is no longer involved with appointing expert witnesses. Because you are indigent, you would have to then request through the public defender's office, which they're going to be of counsel, to see whether or not they have any funds available to hire an expert on your behalf. I'm not saying that they will. I'm not saying that they won't. I don't know because they're their own independent office. But that's where your of counsel attorney is going to come in and maybe give you some guidance there.
Yeah, I object to all of this.
I understand, and I know your objection.
The constitutional rights been broken, man.
I know.
Okay, cool. If you think your constitutional rights have been broken, fucking prove it. It seems like he's realizing, oh wait, going pro se is quite difficult. Maybe I don't have the mental or it's a skill issue. He doesn't have the mental capacity, the technological capacity to represent himself. And now he's like, constitutional rights. He just like picked the first buzzword that popped into his head. Like maybe you should look to your left and go, can you please represent me? I don't do good. That's what he needs to do. He needs to have a nice apology to that attorney.
But there's just because you think it has been, and I'm not saying that you're wrong. Please don't take it that way. But the prosecution has the ability to defend their case, and today is not that day. That day's coming. It's coming. I promise you that. But it's not here yet. Okay? So just bear with us a little bit.
Yes, sir.
All right. I thank you for your patience today and your cooperation. You can go out to the front window where you checked in.
I appreciate your kindness, sir.
All right. Thank you.
It ain't a pleasure meeting all of you.
Can we have Mr. Waters' case?
All right, guys, that's the video. I went live much earlier than I was apparently thought this video was going to take to play. I wanted to get done in just enough time to send you guys over to Mark when he just started or right before he started. Hold that thought. You know what? I'll go dig real quick. Hold on. Oh boy. Let me see what I got. Sovereign citizen wise. No, that's an old Squishy Gardner one from 47 minutes ago. Nope. A sovereign citizen from let me check a page and we might watch a Law Talk with Mike video. Okay, yeah, let's go back. Let's go back again. We might just watch another sovereign citizen video. Yeah, fuck it. We'll watch a Law Talk with Mike video real quick. Maybe generally specifics live. Oh, that fucking cocksucker. Oh. Oh. I am not built for morning streams, guys. Oh. Your cat wrecked your headphones. Hopefully you can read that. I don't think I've ever sent one to Twitch before. So this is going to be a Law Talk with Mike video. You know what I did? I think I sped it up. Yep, we're going to actually speed this one up because it's 30 minutes and we got 40 minutes. I have not watched that court case. do I play League of Legends? Bang. All right, we're going to watch this. Because this was put out 14 hours ago, I have never seen this before ever in my life. So we're going to watch this together. Here we go. It was literally a white guy in a fez on the thumbnail, and I'm like, yeah, I got to watch that.
Your Honor, we could call Mr. Noel.
Court will call Benjamin Noel, 25M 641. Mr. Contreras?
Yes, Your Honor. So I spoke with Mr. Noel. I'm not sure what he's talking about. I know he didn't complete the 24 hours of community service. He informed me of that. He then indicated that he wants this case dismissed against him. I'm just asking, due to the fact that the community service has not been completed, that the fine be imposed. He did complete the classes, but we did suspend a fine. And so I would just ask that that fine be imposed.
Mr. Noel, your position?
I would like to request a dismissal of it because my constitutional rights, if the state is part of the case, they are supposed to extend. They have no choice to a Supreme Court, for one thing. The other thing, the times that I was arrested, they can only arrest me by a grand jury, not by hearsay from a single party.
Well, you pled guilty here, so...
Yes, I know that. Under distress.
Okay. I'm going to go ahead and grant the people leave to file a complaint.
Okay, let's go back. Let's go back.
Well, you pled guilty here, so...
Yes, I know that. Under distress.
He wasn't under duress. He was in distress. He was in distress. Oh, God. I have my fez around here somewhere, but I can't wear it because I have too much hair. If you guys want to see how much hair I have, go back to the very beginning of the video. That's why I was a whole minute late. I've never heard that one before. He was in distress, not under duress. It's like, it's one of those sovereign citizens that it's like their first time like with the script and they don't really know what the fuck is going on. So they're trying to make it work, but they're getting the terminology ever so different.
Okay. I'm going to go ahead and grant the people leave to file a complaint to revoke probation. This wouldn't be one where I would just impose the fine if he's against it. Once that happens, you'll get another court date. You can apply for the public defender. They can file additional motions. There are certain things that you can certainly allege. The court will deny those motions at this time. Those are things you can do in writing, and the people will file a complaint to revoke. Okay?
Okay.
So you'll get another court date in the mail.
Okay.
Thank you.
I want to make you very aware, too, that Executive Order 13818, if you're familiar with it.
I'm not.
Okay, maybe you should take the time to look that up.
What is it?
Executive Order 13818.
And who issued it?
Trump. Donald Trump.
And you think it pertains to your case, 13818?
Of course it does, because it means that all government or state officials, like everybody here, are supposed to cease and desist.
What am I supposed to cease and desist?
So what do I need?
Okay, I almost just tried to pause this on restream. Executive Order 13818 is a U.S. presidential order titled Blocking the Property of Persons Involved in Serious Human Rights Abuse or Corruption. Signed in 2017 and effective December 21st, 2017, it serves as a primary legal instrument implementing the global Magnitsky Human Rights Accountability Act, authorizing the U.S. government to impose sanctions on foreign individuals and entities responsible for serious human rights abuse or significant corruption. So shocker. I haven't heard this one before, but it is also not applicable and nonsensical. Like, I could continue reading this executive order. It declares a national emergency under the International Emergency Economic Powers Act to address the threat posed by such abuse and corruption to U.S. national security and foreign policy. Key provisions include asset freezing, entry bans, and prohibited transactions. None of this has anything to do with a sovereign citizen pleading guilty in court. It has nothing to do with it.
Well, I'm just going to file a revocation at this point.
Okay.
And
So they'll send me.
yeah, and you'll be able to apply for a public defender.
Okay, sounds good.
Did you get that court date? Okay.
Oh my God. This is Zach's fault. I looked, he sent this during the last stream. I know I've streamed 400 times today. I'm like, I have to do it. I have to do it. It's just too good.
It was a good pickup, Mike. It
is too good. Yeah, I mean, you know, he's citing Donald Trump on an executive order for whatever his case is. It's beautiful.
All right, folks, thank you for your...
But we've got more.
Okay, we'll watch more, apparently.
All right, folks, thank you for your time. It's 26 CR4, and we're back on the record. It's been, the bailiff has informed me that this jury has reached a verdict. Is that right? Okay, and who is the foreperson? Okay, is that the verdict in that envelope, please? All right, sir, would you please grab that?
Also, MGT is to blame for some of this.
Thank you, sir. For the record, the defendant is appearing by WebEx. Court will read the verdicts as follows. Jury verdict count number 1. We, the jury, find the defendant, Trenton N. Hammerstrom, guilty of count number 1, menacing. As to the verdict question, did the prosecution prove beyond a reasonable doubt that the menacing was committed by the use of a firearm, knife, or bludgeon, or by the use of a simulated firearm, knife, or bludgeon? Answer yes or no. Answer yes. Foreperson signs. Jury verdict count 2. We, the jury, find the defendant, Trenton N. Hammerstrom, guilty of count number 2, assault in the 3rd degree, knowingly or recklessly. Foreperson signed. Madam Foreperson, is that your verdict? Okay. We need the microphone. I'm just going to poll the jury as well. So what I'm going to do is
Let's go back. Let's go back. So I've been part of this before. I've been part of this before in the jail where we caught I don't want to say the tail end, maybe the middle of COVID, where we stopped taking people to court, even though it was directly next door. Like I could walk out of the back of the police department, walk 50 yards and be at court. So instead of doing that, we decided to buy a bunch of fancy tablets, put these tablets on the wall, walk prisoners to these rooms, put them in there and let them do just this. So many times they would get a conviction and then they would flip out like that's somehow going to change the outcome of the jury finding them guilty, or the judge telling them, yeah, man, you're going to have no bond because you strangled your pregnant wife. And they would flip out. And it's just like, I'm not the one you want to fight. Me and my partner weren't the partnership that you wanted to fight. So it's just like, can you not?
yes. Foreperson signs. Jury verdict count 2. We, the jury, find the defendant, Trenton N. Hammerstrom, guilty of count number 2, assault in the 3rd degree, knowingly or recklessly. Foreperson signed.
There he goes.
Madam Foreperson, is that your verdict?
Yes.
Okay. We need the microphone.
And he looked like such a little guy too. He looked like such a little guy. All right, let's see what we got. Does he come back? Oh, he's on the floor. That's a good way to handle this. Here we go.
Everyone the same question. Sir, was that your verdicts?
Yes, that's correct.
Okay.
Yes. Yes, sir, that's correct.
Yes.
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 Yes. Yes. Yes. Yes.
All right. Thank you very much. Ladies and gentlemen, you have now completed your duties as jurors in this case and are discharged with the thanks of the court. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons involved in the case. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not. If you talk to them you may tell them as much or as little as you like about your deliberations or the facts that influenced your decisions. If any person persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it to me. I'm going to ask that we go back to the jury room. I'm going to meet with you for a few moments. I'll also invite you back into the courtroom if you'd like to speak with the district attorney or any other members of our court staff about your experience. All right. With that, please rise and I'll meet you there in just a moment.
Hey guys in the chat, which AI court channel are you talking about? Because I have a bone to pick with AI fucking channels in general. What the hell is a state national? It's a sovereign citizen with extra steps. They know what they know what comes with the term sovereign citizen. So they use all of the information, rhetoric, pseudo-legal information as a sovereign citizen. They say, but I'm a state national. But if you look up sovereign citizen, it has an umbrella of other terms that they use, and shocker, state national is under that umbrella. Let's see here. Oh, I need the names of AI channels. I found so many. One I followed because I thought it was a real person because the AI voice sounded real. They used an AI image, and then I caught on that like it was an AI channel, right? And then it got demonetized because it was an AI channel that added nothing. It would like make the full screen like a little smaller, add a border, add an intro and outro, and that was really it. And it's just like, okay, that's going to get you demonetized. So they started up another channel, but basically just made the voice feminine and used the same style artwork that they used for the man as a female. And they're doing the exact same thing. And it's just like, it's just going to get demonetized again. Like, what are you guys doing? It's crazy to me. It's crazy to me that YouTube allows AI slop garbage to do any of like YouTube shit. Like, if you want to make AI shorts of fucking lolcows on the internet, by all means, be my guest. You have to know what to type in to actually get the outcome you desire. Where some of these channels, I know I'm going to bring up channels that steal Team Skeptics shit. They literally cut this man out of his own videos and then play his audio word for word through a fucking voice changer or like an AI filter to the point where it's just a different voice saying everything Team Skeptic said, even the dude's ad reads. How are you guys not even changing his ad reads? Like, if you change the ad reads, maybe no one would have noticed. But the fact that you literally do Team Skeptic's ad reads, everyone's going to fucking see it.
Thank you, sir.
Your Honor, are you done with him?
I don't care.
No.
Big ass lawsuit.
I'm sorry?
I care. I got money. My family has money. I'm not being a dick like that, bro. But bro, you got
not yet. If you can, unless you need to take him back, I can meet with him later.
He's all liars, bro.
Unless we need to take him back.
Liars, take me to jail, y'all liars. We're redoing this case. The new judge, like your fucking ass. Go fuck your wife, little dick boy. Dude, fuck your wife. That's what
Right, you can take him back. And mute them.
He can go.
I mean, I really wanted to hear the rest of it. I don't know why the judge cut him off.
Apparently the defendant has not calmed down enough for me to speak with him at this moment. So I'll be back as soon as I can. Okay, thank you. Yeah.
So how do AI channels get enough watch hours to be monetized? Same way everybody else. You put out enough videos, you put a decent thumbnail, you put a decent title, content's catchy enough. Eventually you'll get the watch hours and then you can get monetized. But then after you get monetized, you do the same thing for long enough, YouTube's going to go, oh, you're not adding anything. Reused content, because you're just taking somebody else's video and playing it word for word. That's like if I was to take a Law Talk with Mike video, put it on my channel, hit play, and not put my face on there, not show any text on screen, not say a word. Eventually YouTube's going to go, hey, this channel's getting views, but he's not. He's just playing other people's content. Great example. I'm surprised. What's his nuts? I'm surprised Generally Specific hasn't got demonetized because he literally just puts a video in the corner and plays Magic the Gathering in the background and rarely says anything. Like you add nothing. You're literally just playing another person's video over you playing Magic the Gathering. And then calling it, well, I'm clocking into work today. And it's like, no, you're playing video games and playing somebody else's video. Where, yeah, I'm playing someone's video, but I'm fucking taking the time to fucking stop, say something worthwhile, have a conversation with the chat, and actually make the video worthwhile rather than just sitting there. It's crazy. Oh, he seems like a very respectful and articulate person. Yeah, but, well, weapons, his family has money, don't you know?
I mean, how do I not play these? It's
oh, the next one has my favorite attorney.
This is State of Kansas versus Rachel Macbeth. These are case numbers: MGI 22 CR 459, MGI 23 CR 300,001, MGI 23.
I love this judge because he's always wearing a bow tie. And I know it's just the little things, but it's, yeah, so he went to the Denham School of Transformation. Yeah, the Denham School, the Frogan School of Transformation, where it's like, yeah, I'm just going to steal other people's content. I'm going to let them know that I'm going to watch their content instead of their content, or I'm going to watch their content so that other people don't go over there and watch that content. But then I'm going to call it a job and say, I'm working so hard. I'm working so hard. He's just a man of God. He's working so hard. And he's just sitting there playing video games. If I unbutton my shirt, I've actually, wait, didn't you guys see that video I made? I forgot how long ago it was. It may have been the guy who tried to bring in the Pope as evidence or some shit. I actually wore a button-down shirt, extra unbuttoned with my chest hair popping out. And then I made an intro where I was laying with Ryder on my floor and I said, like and subscribe or the dog gets it, just like Law Talk with Mike did it. Good times, good times.
300,002, MGI 24 CR 56, and MGI 25 CR 120. Ms. Macbeth appears in custody by Zoom with, but separate from counsel, Mr. Latin, stayed by Mr. Gayoso. These matters are set this morning on Mr. Latin's motion to withdraw as attorney for Ms. Macbeth. Procedurally, where these cases stand is there's been a conviction following jury trial in 22 CR 459, and an appeal has been filed, so that appeal process is underway. Case number 24 CR 56 is presently set for a one-day jury trial to commence on June 11, and case number 25 CR 120 is set for a two-day jury trial to commence on June 8. The 223 cases were previously set for one-day jury trials, but those were previously continued at the request of the defense, and those remain not reset at this time. Mr. Latin, you have the floor.
Okay, Your Honor. Yes, in regards to each one of those cases, at 22-459, we filed a notice of appeal. I believe appellate counsel had been appointed, so that allowed me to withdraw for that case. Anyway, on the other four cases that you discussed, Your Honor, I guess you might say that Ms. Macbeth has basically threatened and alleged that she's going to file a disciplinary complaint against me arising out of the 22-459 case, Your Honor. I'm not going to go into all the details on it, but I believe it's basically put me in a position where I can't really provide effective aid to represent her in a fair manner, Your Honor. That really kind of puts us at a point where we do have a conflict of interest. She wants me to represent her there. I need to look at my own. I guess you think about, when you look at these conflict of interest, there's kind of, you look at the person's loyalties and basically.
So it seems to me like the person's trying to blackmail their attorney and say, you do exactly what I say. You do exactly what I say, or I'll file a complaint against you. And as we know, if random people file complaints against attorneys, they might not go anywhere. But if a client files a complaint against an attorney, that they might actually look at that. But she's literally finger guns to his head. Hey, you do what I say. You file what the fuck I want you to file, or you're going to get a complaint. Sketchy.
And my caliber representation in the future for Your Honor. When you start making threats to an attorney that, well, basically what she says that she hopes I enjoy what I've been doing to her, because she's going to basically take my law license away from me. So that definitely puts us at a conflict, Your Honor. And I think it's kind of put me in a position where I don't feel like I can substantially, represent her, and it kind of dilutes my ability to represent her in these other court cases.
That's fair enough, Mr. Lattin. I think that's sufficient basis for you. Ms. Macbeth, just simply, I don't need you to go into the details as to your request for a new attorney. My question for you relates to the status of your cases that are still pending. Do you understand that if I do grant Mr. Lattin's request to withdraw as your attorney of record, that's going to result in your cases being continued? That's going to result in your cases that are presently set for trial being continued. And all that time, I don't know that you currently have a statutory speedy trial right in light of you having a prison sentence in the 22 CR 459, but any constitutional speedy trial right or statutory speedy trial right you might have, that's all going to be counted or assessed against you, since this delay of your cases is based on your actions and your request for a new attorney. Do you understand that?
I haven't requested a new attorney. I have a trial in a month. I'm not waiving my speedy right. He's acting like a 4-year-old. I haven't turned him in. Like, I'm not going to. I want these trials done.
Are you saying that Mr. Lattin is inaccurate in a statement to the court?
I'm saying that that's not a legitimate reason when I have 2 trials coming up in a month. If I turned him in, then yeah, that'd be a reason. But I haven't said anything. It was a conversation between me and my attorney. He's the one breaking privilege, talking to you about it. Like,
he's not claiming that you turned him in. He's claiming that you said you were going to file a complaint if shit didn't go your way. So yeah, him saying to the court, hey, she actually made a threat against my law license because I'm not doing things the way she wants me to be doing them. I don't know if I can represent somebody who's literally like, do what I want or your career's over. I don't know if I can represent them correctly. So she's just being a bitch for being a bitch's sake.
All right. Mr. Gasso, what's your position on the matter, if you have one?
Your Honor, we will leave it at the court's discretion. I know that Mr. Lattin would be in a precarious situation in continued representation based on Miss Macbeth's threats.
All right.
You could have gone with no objection. That would have worked just fine.
Well, unfortunately, Ms. Macbeth, it's your conduct and actions that resulted your attorney of record. I don't believe he can effectively represent you in light of the difficulty you've caused his representation. So we are going to strike the current trial settings. We'll note this delay is a result of defense conduct and action. This will not count against the state for any speedy trial analysis, either statutory or constitutional wise. We're going to review these matters again on my June 4th docket at 9 o'clock by Zoom. Between now and then, I will discuss the review of the cases and see what attorney we can appoint that would not have a conflict, given the witnesses.
Hey, sir, if that's a legitimate reason for him to quit, well, I plan on turning you and Michael Gasso in too, so y'all need to quit too.
You're welcome to do that, ma'am. I'm not going to recuse, but you can do what you feel is necessary. We'll see.
I hadn't seen this one yet, but that's a nice touch.
She had to try.
Okay, then.
She had to try. She's... Well, if this worked for one of you guys, I guess I'm going to have to try it on everyone. Yeah, you have a right to counsel, but not to abuse your legal counsel. Yeah, see, she can get an attorney with her own money, but herein lies the greatest question. Would they go against everything that they stand for to file her dumb shit? Probably not. I was kind of taken back. I didn't think she would just go for it. She just went full send. She's like, well, if this got me out of my attorney, I'm also going to say this about the prosecutor and the judge. Sorry, ma'am. Kim Blandino failed at this, and so did you. Let's go to the next video because Mike's apparently just watching clips.
26M 179.
Isn't this the same judge from the first clip? She rage quit the hearing. Who rage quit better, her or the guy who flipped off the camera?
That's fine. Well,
Yeah, it's just.
All right, Ms. Newman.
Thank you, Judge. Mr. Hill does need to reapply for the public defender's office. He has started that application process, and we've talked about it more. So
That was weird. I haven't seen this. Why is he touching her? That was creepy.
I'd ask for another court date. We can finalize that.
All right. The two cases here. I show the VPO in 26M179 also is DV. Are they both DV? Let me just look. Looks like they are. I have Miss Hill present. Does she wish to address the court or just here to watch?
It's Miss Davis, Stephanie Davis.
What did I say?
Miss Hill.
Oh, Stephanie Davis. I even have it here, so I don't know why I said Hill.
She'd like to address the court, Your Honor.
Indeed, he is.
All right, let's do this.
You just want me to speak from here?
Yes.
Okay. I just wanted to say that Quay never hit me.
You want what though?
Quay never hit me, so I don't understand why we're going through these.
Mr. Hill, look here. He is nodding at her. He is sort of communicating to her. That's not true. I saw you. Hold on a second.
Okay, that
when I asked,
this is like, I noticed you guys said his arm was on her. That'll do it. Yeah, bitch, you better testify the way I want. You better do it. That seems like what he was doing. This screams like, what was that case? I feel like me and KTZ were just talking about it the other day. It took place in Michigan. I think Debbie Davis was the prosecutor at the time. Judge Middleton was the judge, and Debbie Davis was like, Your Honor, we actually think the defendant and the victim are in the same location, because she keeps looking off in the other direction. And then she wanted one of them to like go to the address and show them where they were at. And then one of them got arrested. That's what this seems like. Not good. Not good.
if she wanted to address, he made eye contact and he did this. I don't like that one bit. So I'm not stupid and I do watch.
I'm sorry, Your Honor.
So I don't want you to answer, but I know what I see and I am watching, and you're not in compliance with bond conditions. And so you need to talk to your attorney and listen to what she's saying. You're not the victim here. You're not being victimized. I wouldn't. Okay, go ahead.
Thank you. I'm sorry, Your Honor, for speaking out of turn. And I do accept your reasoning for me to say something, Your Honor. Right now, in this moment, Your Honor, I've been through this court process for this one case, Your Honor, multiple times. I've been arrested throughout this court case multiple times, Your Honor. I do not have any coerce or correspondence with Ms. Davis coming in today to have something to say to you, Your Honor. It is simply my life being put on the line, Your Honor. While anyone would want to speak for me, I'm not making anyone say anything, Your Honor. For whatever reason right now, Your Honor, I am predominantly presumed innocent. I do not have any evidence against.
But the problem is, here's the problem. Yeah, she had the cops go there. It was way back in the day, but I forgot why me and KTZ were even talking about that or discussing that case, but it came up the other day. Yes, that's what I was going to say. Sorry, went half fucking Tyrants Beware brain dead there for a second. First off, these people, if she's the victim and he's the defendant, they should separate while in court. The fact that he even got to touch her, absolutely fucking not. If you've been arrested multiple times on this case, if you've been through this court system multiple times for things like this, maybe y'all shouldn't be together. I know this is going to hurt some feelings, but we as a society should be able to say, y'all got to live on different sides of the country. Y'all got to lose each other's numbers. Y'all got to change each other's names. Something's got to happen because y'all can't be together. We can't be going to your house every other day because you're beating on people. We can't do that. But here we are. This guy's out here. I'm fighting for my life. Or you can just not put hands on people. It's really easy.
Me presented from the DA that I did anything on this case, Your Honor. The only thing that I have to
I don't know what he's charged with, but just lock him up.
say right now is that I'm not disrespecting your courtroom. I'm not overstepping in your courtroom, Mr. Briggs, Your Honor. All I'm saying, Your Honor, is that I've been innocent throughout this whole case, this whole time, Your Honor, and the DA has never said to my public defender or to you, Your Honor, what is keeping me in custody or keeping me coming back here. I haven't had a preliminary hearing. I haven't had anything to do with this case other than showing up and making sure that I have a public defender standing next to me every time. In this case, it doesn't seem like I need to keep a public defender because there is no evidence against me that I did anything to Ms. Davis.
Is that why you're not reapplying then?
No, sir, Your Honor. I'm just putting as many applications to the public defender's office as I can. My PDL is for some reason locked in my settings that I don't know how to unlock it. So I send the PDF over to the public defender's office every week, and they call me back saying that, can you just send me a screenshot of the PDF? And I've done that multiple times. I'm sure she can go into her files and she can kind of back that stuff up, Your Honor, that I've just been sending PDF after PDF file.
So I guess I'm a little confused. This case, the newest case is only from January. And I show you maybe here, March 26th, you were in person, and I would have told you to go right over there in person, because if you do it by email and you didn't listen to me, right? You probably were like, well, I'll just email, easy enough. It isn't. It's a lot harder. And I've gone in and you can get it done, but I don't have 100%. You know what I have 100% is if you go over and you hand it to them.
Yes, sir.
Okay. Then you don't have a public defender on this case because I can't get you to go over in person and apply in person.
Yes, sir.
And then I have 25M 4067. Now that looks like that case was from December. And so you say every time I keep coming here and you're dragging it out, Judge. I only see that you've been out of custody one time on that case. So at least in the ultimate scheme of things, this is not a case that's being dragged out. I just need
Your
a
Honor.
public defender.
Yes, sir, Your Honor.
And to comply with probation. And now there's a new case in Grand County, or Gilpin County rather. And so there's a warrant for your arrest on those.
Yes, sir.
And I understand that it's a hassle, but the bottom line is I have to have you comply with my orders. And I do want to answer your concern, which is they haven't shown me the evidence, because people hear all the time, I get my day in court. That happens at trial. So they don't have any burden other than to have a judge find probable cause for arrest. And then you get a lawyer and everything slows down. I have had and seen cases get dismissed over the years because they don't have enough evidence to go forward. Whether these three cases fall in that category or not, I don't know. But my experience is that attorneys have better luck getting them dismissed than someone on their own. They could have dismissed it long before now. If they think there is some evidence against you, then they have to go forward. Hold on, let me finish.
But that's what Ms. Davis has been doing for me, Your Honor, is that she's been contacting the DA and letting them.
Okay, so I just want to point this out because I'm glad the judge just said that. One of the Chris Ryder simps. I can sense a headache coming, so I'm preemptively taking medicine. Okay, so a Chris Ryder simp came to my chat in regards to Chris's case taking almost 3 years so far. In October, it'll be 3 years. And they're like, well, duh, they want to extend it as far as they can because it'll get their charges dismissed. And it's like, well, in some cases, but if they're holding it out for 3 years and keep you coming back and back and back and keep holding you in fucking bond violations and they keep sending you back and back and back, the judge just said it. Clearly, if the prosecutor's going to let it go on for years and you still collecting more and more charges, clearly the prosecutor sees something worth pursuing or they would have dismissed it already. That's just my opinion. But it's like, that's also the judge's opinion rather than some random Chris Ryder mentally disabled simp that comes to my chat to get dropped on their head by me. Like, it doesn't make any sense. So anybody who's like, oh, just drag it out as long as you can, it crosses a line where you either dismiss it or you keep it going forever because you see something in the case worth pursuing.
No, that. No.
So I'm not going to modify the protection order
I'm just creeped out here. I don't know what's going on, but the whole thing creeps me out.
today. I may consider it later. Too many cases, too much going on. And I'm just looking at the affidavits. And on one case, there's at least an allegation that you grabbed her by the face. She had blood on her face. The police said the situation bore that out. And so they have that charge. And then at the very least, they found you in contact with her, and that violates the protection order here. So I understand. I'm happy to set these cases for trial. Obviously, I don't want to do that until he has the opportunity to get the public defender out of custody. But I do have concerns that, the people can look into it. And I'm not here to say violated or didn't violate, but we're sitting together having contact, and we're certainly communicating. And right now, actually it says face-to-face in public in the one case, so that may be allowed. Let me look on the other one. And then looks like I've modified it substantially, Ms. Davis. I'm not going to modify.
Yeah, Erica, it looks as if he already has a warrant somewhere else. Oh, God, this... I'm torn because I'm of the opinion we should be going extremely hard on certain crimes and lax on other crimes. And this is one of the ones where you max it out. You max it out. Especially he's already got a warrant somewhere else. Just max it out, my guy. Like, some people, this is going to sound, again, clip me, bitches. There's a certain group of people, no race, no ethnicity specific, but just a certain group of people that just shouldn't be in society with the rest of us. This guy's one of them. Chris Ryder's another one. Like, they just don't need to be in civilized society. They need to be on an island somewhere, but eating grass or something, away from the rest of us, because they're just undeserving of civilized society.
Fight again. I understand you're saying nothing happened. That isn't what they found out the day of
the evidence
arrest.
says
And
otherwise.
Miss Newman has access to the police reports. She can tell you what the allegations are. Go ahead.
I don't have access at this point, Judge, because I'm not entered on the cases, so I don't have to discover you.
Okay, so you need to apply, but if he's in custody, did you want to? Well, he's going to be remanded. He'll be in bond hearings. Please let them know so that you can reach a stipulation.
I will, and will he be set for this afternoon's bond?
No,
Judge? Tomorrow. Okay. I do want to just let the court know that while I'm here as a courtesy, I'm not entered on the cases, so I could not advise Mr. Hill on the motions to increase. I was able to see that there were warrants. I did advise him of that, and he did choose to stay and turn himself in on those. And so I just want that to be on the record as well.
Make sure that the public defender readdresses that in front of whoever the judge is tomorrow. It's pretty Devereaux, I think.
Yes.
So I think that's fair.
To be fair to this guy, you're doing better than BSBT. You found out you had warrants. You still came to court and let yourself be arrested and be turned in so you could deal with those warrants. Unlike BSBT, who's on year number 2 of fucking fleeing from the police because he's so scared of fucking Judge Shackelford. Ben Darling, if you've read statistics like that, I've read statistics similar to that. Yeah, it turns out if those 20% of the population that commit all the crimes are in jail, those crimes wouldn't be taking place. But that's just my opinion. So, Parsons 1122. I actually had the same thinking when it comes to frauditors. I want to have frauditors. I want to give them an island, collect all of them up, throw them on an island with one phone, one power bank, just to see what would happen. Because they would only have themselves to audit. And then after they pepper sprayed each other and got it on camera, and then their cameras ran out, I just wanted to see what they would do. If they would after their camera's battery ran out, after the power bank ran out, after their pepper spray was gone, would they like evolve into a normal person? Or would they revert back to being a caveman? These are the experiments that I want to conduct. I'm a scientist.
I do appreciate you staying here and taking the medicine, but slow things down. You're right. There isn't proof beyond a reasonable doubt, but there is probable cause. So defendant will be remanded on bond hearings tomorrow. And then do we give court dates or they just give them tomorrow?
Yeah.
Okay. That'll be it for today. Thank you.
All right. First of all, I find based on the petition and the testimony in court, including admissions made by the respondent, that the court has jurisdiction over the petitioner, the respondent, and the minor children. Venue is proper here because the children reside here. The petitioner resides here. And at the time of the behavior alleged, the respondent resided here. I find that the respondent has abused the petitioner and the minor children identified in this order within the meaning of the Domestic Violence Act. The actions of respondent will likely cause irreparable harm if continued abuse unless they are prohibited. It is therefore necessary to grant the requested relief in this order to protect the petitioner or other abused persons. You ask what's going on. I've entered an order of protection that is set, and let me finish talking before you totally freak out, okay? I have set this to expire on May 4th, 2028 at 11:59 p.m. In the meantime, it prohibits any contact with Harmony Morgan or your children. And that includes indirect contact, contact to a third person. So no social media, no asking
He really doesn't play. He's got some edge for an older guy.
Somebody to talk to them for you, no calling her.
Going full military on this one. I'm going to piggyback off a law talk with Mike for a second. I love older judges because most of them simply don't give a fuck anymore. So they'll just light people up for the sake of lighting them up. Or they'll call them dumb just for the sake of their acting dumb and they should know about it. Older judges just have no filter and I love that. Like some of these younger judges try to understand why they beat their wife or why they committed murder. And it's like, I don't care why they beat their wife. Don't do it. If you think, damn, I'm going to beat my wife, divorce her and leave. If you think I'm going to beat the mother of my child, I guess that's where you call it quits. If you're thinking I'm going to murder someone, that's kind of on you. You know what I mean? I don't have to understand why you did it. You're here. Here's your sentence. Good luck and Godspeed. Yeah, exactly. Old judges and old cops have already used up all their fucks. Yeah, they have no more fucks to give. That's why I always say, sovereigns are like, oh, let me see your supervisor. And it's like, that's the last person you want on scene. The young cops that are touchy-feely, oh, please get out of the car. Those are the people you want to deal with. If they want you out of the car, you're getting out of the car. When the 30-year-old grizzled veteran with 3 divorces under his belt and a bunch of child support gets on scene, he does not care. This is just another day for him. He's going to break your window and pull you out of the car. There's no, well, don't you know sovereign citizen? He's heard it all before. He heard it all before and he knows it's bullshit. Come on and get out of the car.
Parents to try to get them to get a message in, just zero contact. I'm going to expect, because I've explained the terms of this order to you, that you stop downstairs at the clerk's office on your way out and get a copy. It'll be scanned in. All right. Okay. Now, the reason I'm telling you not to freak out is she has filed a
don't freak out
DC case. That means a divorce with children. Okay. Petition for dissolution with children. Same judge, I'm gonna have that essentially consolidated with the family law case when the family law case is put in front of me on May 20th or 26th, whatever it was. It's gotta be May 20th. I'm not gonna be here on the 26th. I can modify that order if we decide that that's appropriate in the family law. Okay, so it's not necessarily forever. But you ask, can I be heard? Absolutely. And she's got a lawyer.
This is weird. They're consolidating a divorce case with a criminal matter. That procedurally is very strange.
I'm going to suggest that you get a lawyer if you can possibly do it, because this is going to be very, very stressful for both of you. All right. But that's it for today. I want you to stop downstairs and get a copy of this order on your way out. I want you to do the same. All right. I will tell you that violation of that order, if she calls the police on the first offense, if they take you into custody, is a Class A misdemeanor. Second offense is a felony. All right. I would like you to take off right now.
Oh Lord, are we going into the who would survive? Yeah, I think they would probably be eating the carcasses of Georgia Transparency and Glenn Serio for quite a while. But those bite marks would look so goofy because most of them have fucked up teeth. You'd have the broken system, broken trust, JC News Now bites where they're missing like every other tooth. It would be so goofy looking.
Now, get your copy of the order and leave. Because as soon as she leaves the building, my bailiff over there, Doug, will let you go.
Hey, Doug.
And you get your copy of the order and then take off. But in the meantime, you should just have a seat in the back, okay? Good luck to both of you. Thank you. Yeah, here's a copy of the. Okay. Yeah. Then I could talk to them. This. Hold on. I'll think you lied to me. Thank you for lying. Sir? Yes, sir. Listen to me. What you just did, accusing a judge of lying to you, is contempt of court.
What does it record in here?
Everything's recorded.
Okay, that's perfect. Because
sir, if you keep talking, I am going to find you in contempt of court. I'm going to remand you into the custody of the Boone County Sheriff. Do you understand what I'm saying to you? Sir. You need to stop calling me a liar, and you need to stop accusing me of doing something nefarious. You admitted this behavior.
No,
and so, sir, I'm done with you. You just have a seat in the back and calm down.
But the case is over.
Sir,
just give it a minute.
Have a seat in the back and calm down.
What is up with all these little guys in court? What's up with all these little guys in court getting so pissed off at the judge?
No.
Yes.
What about the DC?
Oh, Lord. Did he wear basketball shorts to court?
No.
Yes.
My man wore basketball shorts to court. I don't know what to say to that. I'm a little taken back. We talked about BSBT wearing a Honolulu blue Lions t-shirt for his court shirt in damn near every court appearance that I've seen. Well, when you only got like 2 or 3 shirts, I'm assuming that might be the best. Second was overall guy from the first video, and now we got basketball shorts guy. Do better, society. Do better. Maybe my parents just ingrained in me that like if you do something that's serious, you have to dress for that level of seriousness. If I'm going to court and in this situation where the judge is going to fucking tear me up, I'm going to wear a suit or some dress pants and a nice button up. I'm not going to wear a t-shirt, gym shoes, and some basketball shorts.
What about the DC case?
It's no. No, it hasn't been served. I don't have a notice. I don't have anything given other than the copy of the complaint.
I like him. He's fun. He's fun. I hadn't seen that before. Although dropping a nefarious on this guy, there's no way he understood that. All right, this is what I have. I got extra good nuggets. That was fun. Good day of streaming. Thank you all for coming out. I appreciate it. Oh, I think I also have to blame MGT for this.
Yeah, that's it. That's all I got. Law Talk with Mike was done with that video. I was done with that video. For some reason, it doesn't want to bring up a normal screen. But hey, I can fix that. I'll show you guys one more thing before we get out of here, and I'll send you over to Mark. Make myself smaller. If you guys aren't subscribed to Reading the Room, go do that. KFARR's Reading the Room. You type in KFARR, 3 channels pop up. Subscribe to all of them. That's the video. That is the video. Oh, that's why it's being weird. Anywho, that's it. I've got a video coming out at 1. I've got a video coming out at 5. And I got Booze and Body Camp tonight if today is Wednesday. Today is Wednesday. So yes, I've got 3 more times. And I have a short coming out at some point. The day is chock full of KFARR. So that's it. I'm going to send you guys to Mark. Watch my outro. And then you'll be auto-directed to Mark's channel. He just started 3 minutes ago. Bye.
You're still here? It's over. Go home.